Congresspersons, and 2, Administrative Office of the U.S. Courts, the U.S. House Committee on the Judiciary, and the U.S. Senate Committee on the Judiciary. The conduct of Mukasey and Griesa is, quote, prejudicial to the effective and expeditious administration of the business of the courts, Title 28 U.S. Code 372C1. Which business, Glendora adds, is justice. Isn't that the business of the courts? Obstruction of justice is a felony, Title 18 U.S. Code, Section 1503. Further, these 372C1 complaints go on the Internet for the whole world to read. B. Mukasey, Griesa, Moorhead, and Shapiro, 2 fly-by-night law clerks. First job out of law school is to be a clerk, and then they go on. And it's the first year of their training to be a crooked judge. Mukasey, Griesa, Moorhead, and Shapiro have also violated infra the 18 U.S. Code, Section 1001, that whoever in any matter within the jurisdiction of any department or agency of the United States knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, or makes any false, fictitious, or fraudulent statements, or representations, or makes or uses any false writing or document, knowing the same to contain any false, fictitious, or fraudulent statement or entry, shall be fined under this title or imprisoned not more than 5 years. Well, Mukasey and Griesa should be both. They should be fined and they should be imprisoned. C, Part C. This so-called order was received by Glendora on February the 11th, 2001, and it was memo endorsed by Glendora on February 18th, 2001. First of all, the court's caption is wrong. This is not the correct caption, and you mustn't change anything in a caption. Even if there's something wrong, you mustn't change it. So writes this Mukasey, since 1993, plaintiff has filed over 20 lawsuits in this court alone. I think it's more than that, much more than that. And Glendora says, right away, immediate prejudice. So what? What are the courts for? They're there to file lawsuits to get justice. So is there any law broken here? That an American citizen, instead of going out and punching these defendants in the nose, which they deserve, instead Glendora files a lawsuit. That is the way you do in America. Law and order. After warning plaintiff several times against continuing to file frivolous lawsuits, see Glendora versus Porzio, and I don't know the date of that. Glendora says, because of your immediate prejudice, you write 2 lines, and already your prejudice is blatant. Recuse, Title 28 U.S. Code, Section 144 and Section 455. Now, Glendora says she has never filed a frivolous lawsuit in her life. What has been frivolous is the, quote, decisions, orders, unquote, of the judges. This opener of yours, since 1993, quote, unquote, wins Glendora's point instantly that she cannot get justice in the Southern District of New York and Acker's transfer is illegal. 28 U.S. Code, Section 1404 mandates that a transfer be in the interest of justice. Glendora can already see this paper is written by a fly-by-night law clerk on her first job or his first job out of school. And citizens' taxpayer money is squandered on this pablum. So many lawsuits have been filed because so many crooks have broken our laws, and so many lawyers have greedily sopped up the money as a liar for hire, and because so many law clerks, other clerks, and judges have violated the law so many times, an IQ of 70 should be able to understand this. Says Mukasey. Southern District of New York, 1997, Glendora versus Washington, Southern District of New York, 1997, Glendora versus Rosanna, Southern District of New York, May 1st, 1998. This court barred plaintiff from filing any new lawsuit without first obtaining the court's permission. I get the static out. Must be a loose wire. These judges have a few loose wires. Glendora versus Bryant in 1998. Well, Glendora says, this was Grieser, who hardly qualifies as a court, quote unquote. And this is why Glendora files in other courts. And this is why Acker's transfer is illegal. Glendora did not file this lawsuit in your jurisdiction, in your court. Says Mukasey. In the same order, plaintiff was warned that more serious sanctions, quote, including but not limited to monetary fines, may be imposed by this court should plaintiff fail to heed this court's orders in the future. And Glendora says, well, she never filed another lawsuit in this court. It is a useless court. And Glendora has no money, so how can you fine her? Again, this is Grieser, who does not qualify as a court, quote unquote. Article 3 says a United States District Judge is a United States District Judge not for life, but for good behavior. Grieser has not shown good behavior. He must be impeached for his treason to America. Glendora currently has a petition in the United States Supreme Court filed December 13th, 2000. Now here's a footnote by this dumb law clerk, first job out of college. See Glendora versus Washington, Thomas P. Grieser, 1997. Listing plaintiff's prior case citations. See also Glendora versus Porzio, 1998. Barring plaintiff from filing future informer paupers applications in non-criminal cases in the Supreme Court. And the Supreme Court is entirely wrong about that, and that is definitely a blot on the escutcheon that they should do anything that un-American. You understand now, don't you, that the Supreme Court of the United States is not for poor people. Poor people cannot afford to go to the Supreme Court of the United States. You have to be rich to go to the United States Supreme Court. That is their record. All denied without recorded dissent. And the Supreme Court says Glendora has filed 14 petitions in the Supreme Court. But Glendora versus Porzio in the Second Circuit, warning that plaintiff may be subject to sanctions if she initiates any further litigation of frivolous claims or appeals. But that can only be in the Southern District of New York. And after I found out how wretched these people were and what traitors they were to the United States of America, I refused to file any lawsuit. I refuse to seek justice in the Southern District of New York. So what's wrong with filing lawsuits? What law does it break? Did Congress make a law that you couldn't file lawsuits? I don't think so. That would be unconstitutional. The Constitution said you can redress, you can petition your government for redress. Now this is more prejudice, Glendora writes, and more lack of qualification, more cheating, and more ignorance. there is no mention of the dissent that Glendora got in the United States Supreme Court. Justice Stevens said, no, you can't do that. You can't stop Glendora from writing a petition for writ of certiorari prospectively. You can't do that. You have no authority to do that, U.S. Supreme Court, and it's un-American to do that. And that was the dissent of Justice John Paul Stevens. This brings us, Glendora says, to disjointed footnotes. Write an integrated paper, but then Glendora says it takes integrity to write an integrated paper. Let's get rid of this static. It's a great microphone, but it has a short, obviously. Why wouldn't it? Because the wire is always being pulled, because the wire is always getting under your feet. You should be ashamed of your Gestapoism, Glendora writes, and that you have betrayed America. Your medievalism is abhorrent to real Americans. How did you ever pass inspection as a United States District Judge? Says Glendora, what happened to your oath to enforce the U.S. Constitution? This is apostasy. And Mukasey, page 1. Go to Mukasey's page 2. Writes Glendora, the Southern District of New York is everything Glendora said it is in her legal paper to Alabama ACCA of September 17, 2000. Said Glendora about the Southern District of New York. Glendora wrote an erudite 150-page paper on why her case cannot be transferred to the corrupt Southern District of New York, powerless to perform, physically, morally, and intellectually and legally same. Powerless to form. This court is devoid of capacity, skill, completeness, sufficiency, facilities, force, caliber, strength, capability, competence, qualification, aptitude, faculty, talent, proficiency, inter alia. This court, the Southern District of New York, has been rendered valueless and taxpayer waste by its impotence, its inability, and its ineptitude. Glendora has personal knowledge of same. Glendora has a right to fair forum. Congress, read Moore's, favors forum shopping. We are up to page 10. The order is a nullity. The court has to grant plaintiff's motion for informer paupers before it can order a transfer. Now, Alabama ACCA didn't do this. Without even granting informer paupers, he goes ahead and rules. An informer pauper's motion is a motion to proceed without payment of fees. And you can't proceed unless you rule on the motion. This court, meaning the Alabama court, has not granted the informer pauper's motion, the order, ergo, ACCA's order of transfer is a nullity. And I'm telling this to Griesa and Mukasey, who don't deal with the facts and who don't deal with the law. They are crooks, in other words. End the extract from Glendora's September 17th Alabama paper. Now, Glendora would never be foolish enough to seek justice in the Southern District of New York. She would never file a case in the Southern District of New York. Pew. Pew. It is a useless court. Indeed, it is a worse than useless court. It is deleterious to the United States of America. You know, useless goes down to the scale, to 0. But this court goes below 0 and into minus. All the judges should be cleaned out and do penance for 20 years for the Peace Corps, unless they would continue their corrupt ways there. The Southern District of New York needs to be absterged. It's a Latin word meaning wipe clean. Wipe it clean. So why does the law clerk, quote unquote, herein, babble about filing a lawsuit in the Southern District of New York? Glendora did not and would not. Glendora was opposed from day one to transferring to the Southern District of New York and wrote a Rule 60B motion immediately for relief from Alabama ACCA's so-called order. We are up to page 11 out of 60. And now I'm going to take a break. I had to shovel. I shoveled for a quarter an hour. The snow is very heavy because it's wet. I shoveled the space between the 1980 Lincoln and the 1993 Lincoln, and it's nice and sunny and it's melting and you can move it. 2 boys came here last night looking for work, and I told them what I wanted. To the front of the 1993 shoveled out, back of the 1980 shoveled out, and in between shoveled out, and all the snow off the cars. And I said, how much do you want for that? And they said $10 for each of us. And I said, it's agreed. Go ahead. So after 10 minutes, one of them rang the door, their bell. Their names were Travis and Jay. And one of them rang the doorbell and said, this is too hard. We want $20 a piece. So what did I say to that? I said, no. Nothing has changed since we made the agreement. You have to keep with the agreement. And so I went back to getting supper, and the doorbell rang again. Can we come back tomorrow? This is too hard. So I said, you're off to a bad start in life, but go ahead, it's your life. And so it didn't get done last night, but it's moving a little bit today. So we are up to page 11. This is McCasey and Grieser, 2 crooked United States District Court judges in Manhattan. Glendora says it is not Glendora's fault that the case is in the Southern District of New York. It's the fault of a lethargic Alabama United States District Judge who took the easiest way out. Being in the United States District Court, Southern District of New York, is not voluntary. It is not of Glendora's volition. So all of law clerk's rhetoric is irrelevant because it doesn't apply. And now we start McCasey, page 2. McCasey writes that on September 18, 2000, the court's pro se office received plaintiff's instant complaint. Glendora has failed to comply with the court's order by failing to seek leave accordingly. Leave to file the instant motion is denied. I didn't seek the leave, and now they're saying this, the seeking the leave, which didn't happen, is denied. And how can I seek leave to file a case in Alabama? What jurisdiction do McCasey and Grieser have over filing a case in Alabama? So you can see this bunch of lies, and you can see how they're corrupting this court clerk. Glendora says this is stupid. Glendora did not put the complaint there. It was put there under her vehement protest. I don't want to be in this dumb United States Southern District of New York any more than they want me to be there. 23, and Glendora says this is a lie. 24, this is a cheat. 25, and citizens' hard-earned money is used for this slop. 26, and another American youth is, law clerk, quote unquote, is corrupted. Page 12. And Glendora says it takes his or her next step in lessons how to become a corrupt United States District Judge. So, furthermore, on April 29, 1999, this court consolidated 3 of plaintiffs' cases and disposed of them sua sponte. Isn't that justice? Isn't that justice? See Glendora versus Pinkerton, Security and Detective Services. Well, Glendora says, Glendora cannot get justice in the Southern District of New York by your own record herein. 28 U.S. Code, Section 1404, states the transfer must be in the interest of justice. Well, this is what Congress said, and this is what Congress meant. Court did no such thing. Glendora never received any such notice. Prove your case. You are in violation of Federal Rules of Civil Procedure, Rules 77, 78, and 79, how to file cases and how to notify litigants, if any such thing ever happened. Glendora would oppose any such cheat instantly. Glendora further has never received any notice that Sweet allegedly dismissed her case against Pinkerton John Walsh, who tossed Glendora's tape recorder into the air and let it fall to the desk. So this is another cheat by arch-cheat Sweet. Griesa is not far behind. Glendora just sued both Sweet and Griesa in the United States District Court, Arizona, in her omnibus lawsuit filed January 4, 2001. Now, Mukasey quotes Griesa. They are colluding. They are clones. Now listen to this, what this dumb Griesa says. Plaintiff has filed these complaints without seeking prior leave to file with the court, a clear violation of our prior bar order. What complaints is he talking about? Because I never saw this. The fact that plaintiff did not directly file these complaints in this court and instead filed them in a court without jurisdiction, who then transferred the complaints to this court, is a transparent attempt to evade this court's bar order. That's stupid. That's nothing but supposition. That's nothing but conclusory. He has no evidence. There was no hearing. It is clear from the complaint that all of the relevant facts occurred within the Southern District of New York. Yes, because the Southern District of New York is so crooked. Plaintiff's attempt to circumvent our order by filing in another district is an affront to the authority of this court. Who believes in the authority of this court when nothing but idiots are there? Which will not be tolerated. Ho, ho, ho. While we do not impose further sanctions against plaintiff at this time, we reiterate our warning that any new lawsuit plaintiff seeks to file, regardless of whether it is transferred to this court or filed here in the first instance, that does not seek permission of the court will be returned to plaintiff. Big deal. Big deal. Now can you see how dumb Griesa is? Can you see how dumb Mukasey is? Can you see what has happened to your courts? They've been taken over by gangster idiots. And it says Glendora number 99 Civ 3086 TP Griesa slip. I don't know. What is the name of this case? I would like to know the name of this case. And why don't they say what it is? And who are we? This is nothing but TP Griesa. Who are we? If it is transferred to this court, quote unquote, it is not filed by Glendora in this court, quote unquote. You do not have jurisdiction over the other district courts, and you show cause. Now, Glendora says this is not the truth. B, Glendora does not need leave of the United States District Court, Southern District of New York, to file a complaint in another United States District Court. This is egomania. This guy is a United States District Judge. He should be impeached. Transparent attempt, quote unquote, is conclusory and has no substantiation. D, the courts must rule on facts. E, and this is why Glendora cannot get justice in New York, the old boy network. F, in addition to the Southern District of New York's crimes exposed by Glendora for years on television and abundancy of same in the record, if unexpurgated, Title 18 U.S. Code 2701, Glendora attempted no such thing. She has a right by First Amendment to petition her government for redress of wrong, and when her district court is no good, she has to go to another, and Griesa cannot stop that. G, plaintiff's attempt to circumvent an order, quote unquote, is an unproven allegation, and no law is broken, filing cases, seeking justice in other courts. J, Griesa has no legal basis. K, just as puerile temper tantrum and apostasy. 33, we're on page 15. What good is it to rid ourselves of inept Chief Judge Griesa and get a clone in his place? This is more abuse of the public courts, Title 42 U.S. Code, Section 1985, Civil Rights Violations, and Section 1980, the first section is 83, Civil Rights Violation. Second section is Section 1985, Conspiracy. 34, quote, which will not be tolerated. Griesa does not have jurisdiction. He has been a disabled bench sitter for years. He asks jurors to be fair and impartial, quote unquote, and he flunks to a nadir. Glendora did not seek to file a new lawsuit in Griesa's jurisdiction, and precluding her in the Southern District of New York is more traitorship to the American system. Not that I care. I would never file a lawsuit in the Southern District of New York again. Quote, regardless of whether it is transferred or filed here, unquote, is something that Griesa has no authority over. Quote, will be returned to plaintiff, unquote, has caused Griesa to be sued many times. D.C., Boston, Philadelphia, Arizona. This is a poor excuse for being paid to be a United States District Judge. He has abused the pro se office for personal affairs and theft of service. Now McCasey's law clerk writes, Rule 11 of the Federal Rules of Civil Procedure provides the minimal threshold requirement for all documents presented to the court, whether offered by counsel or the party, including a pro se litigant. Glendora says, Glendora has met them all. Clerks, lawyers, and judges have not.